This right here is a Hecka Good Gov vid. It ain't the first one, but boy howdy, it's the second one. In this video, we will be covering the judicial review in the Supreme Court. The definition of the judicial review is the power of the courts to declare laws and executive acts unconstitutional. The Supreme Court is the ultimate judge of whether a government action conforms to the Constitution. Our first example of the judicial review being put in place is the case of Marbury v. Madison. This case began after President Adams, who was about to leave office, created dozens of new federal judgeships and appointed Federalists to fill these spots. Federal judges serve for life. Therefore, the appointments of Federalists would ensure the continued federal influence in the federal government. Adams was not able to fulfill all of his commissions or appointments before he left office. Angered by Adams' idea, President Jefferson, newly in office, decided not to deliver the remaining commissions and appointments. William Marbury, being one of the men who did not receive his commission, took his case to the Supreme Court. His argument was based on Section 13 of the Judiciary Act. This empowered the Supreme Court to issue a writ of mandamus to force an official, being Madison, to perform a duty for which he was legally responsible. Chief Justice John Marshall of the Supreme Court made a decision that put an end to the case, saying that Section 13 of the Judiciary Act is unconstitutional. Article 3 did not give the court the right to issue a writ of mandamus. Judicial review has since been used in all court decisions, the downside being that any defendant can argue that a law decision is unconstitutional.
You still haven't delivered those judicial commissions?
You still in the NBA? Our next area of explanation is the Supreme Court. The definition of it is the highest level of court in the U.S. federal government, or another definition is the court of last resort in the federal judicial system. In the Supreme Court, we will be discussing the selection process of Supreme Court justices. Supreme Court justices are appointed by the same system that federal judges are appointed, although the appointments of Supreme Court justices attract more attention. When a vacancy in the court appears, the President compiles a list of candidates. The Department of Justice then conducts background checks to see who is eligible for a position such as this. Lengthy interviews are a common tool to find this worthiness in each candidate. In the past, a group of voluntary lawyers, being the ABA, or American Bar Association, have been asked upon by the President for possible candidates. There were many aspects of criteria that were to be met by candidates such as compassion, decisiveness, and patience. Based off of these qualities, as well as many others, candidates were rated as well qualified, qualified, or not qualified. Some people argue that those voluntary lawyers, called the ABA, should not have so much power in the judicial appointments. This argument was solved by President Bush in 2001 when he ended the tradition of formally consulting with the ABA. In this video, we covered the judicial review and how it was begun and that it has been used in almost all court cases since then, and the Supreme Court and how they are the last resort in our court system.
This has been a Hecka Good Gov vid number 2 by James Ranstead, Margaret Paul, and Rachel Woodcock.